Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss Bharatiya Sakshya Adhiniyam 2023 section 46 to 50.
So let's talk about something fascinating. When you're in a civil court, how much does your personal reputation actually matter? You know, what people think of you? Well, today we're going to decode exactly that, looking at the rules for character evidence under the brand new Bharatiya Sakshya Adhiniyam 2023. All right, let's dive right in with a classic scenario. Imagine you're in a business dispute over a contract. The person on the other side? Well, let's just say they have a reputation around town for being, a bit dishonest. The big question is, should a judge even be allowed to consider that when making a decision? That simple question, it gets right to the heart of what we're talking about today. Well, the law has a pretty clear answer to that. It basically says, focus on the facts, not the person. Think of it like this. The court is a referee looking at the play-by-play of what actually happened in a specific situation. Its job isn't to judge the players' personalities or their past games, but to rule on the facts of this particular incident. And this isn't just some vague legal philosophy either. It's written right into the law. We're talking about Section 46 of the Bharatiya Sakshya Adhiniyam, or BSA for short. And what it says is, look, in a civil case, you just can't bring up someone's character to try and prove they probably acted a certain way. It's a really crucial safeguard against letting prejudice sneak into the courtroom. Okay, so what does that actually mean in practice? Let's break down the key ingredients of Section 46. So there are basically 4 key things you need to remember here. First, this rule is only for civil cases. Second, we're specifically talking about character evidence, things like someone's reputation. Third, this evidence is considered irrelevant only when you're trying to argue about how someone likely behaved. And fourth, and this is a big one, there's a loophole. Character can become relevant if other facts in the case open the door for it. We'll get to that. And just so we're all on the same page, what exactly are we talking about with civil cases? Well, these aren't criminal trials. These are the disputes that happen between people or companies. Think contract disagreements, arguments over property lines, family law issues, and even personal injury claims, what lawyers call torts. Okay, let's circle back to our contract dispute example. Remember the guy with the shady reputation? Well, Section 46 means the other side absolutely cannot stand up in court and say, hey, everyone knows this guy is dishonest, so he must have committed fraud in our deal. The law blocks that completely. Why? Because that's just an assumption. It's not hard evidence about this specific transaction. But, and this is a really big but, the law is rarely black and white. Just when you think the rule is simple, character is out, there's a massive exception that completely changes the game in certain situations. So here's the exception. Character evidence is allowed when a person's character isn't just some background detail, but is actually a central part of the argument itself. The legal phrase for this is when character becomes a fact in issue. It's no longer a side character in the story. It's the main plot. In these cases, evidence about someone's character isn't just allowed. It's absolutely essential to get to the truth. And what's the perfect example of this? Defamation cases. It makes perfect sense, right? If I sue someone for ruining my reputation, what is the entire case about? My reputation. The court has to examine my character to figure out if it was actually damaged. In that kind of lawsuit, a person's character isn't just relevant, it's literally the whole point. Now, this isn't just something written in a new law book. These ideas are deeply rooted in court decisions. So let's take a look at what the Supreme Court has had to say about all this. In a really important case, Gopal Krishnaji Ketkar, the Supreme Court laid it out plain and simple. They said, and I'm paraphrasing a bit here, that civil cases have to be decided on the actual evidence and the facts, not on assumptions about what kind of person someone is. You can see how this thinking is the direct foundation for the rule we see in Section 46. And then, in another key case, Subramanian Swamy, the court explained the other side of the coin, that big exception. They pointed out that in defamation cases, character can be relevant because, and this is the key part, a person's reputation itself is the subject matter of the dispute. See? It stops being a sneaky assumption and becomes the central piece of the puzzle. That's the logic behind the exception, right there. So you might be wondering, is this whole idea brand new with the BSA? let's quickly compare it to the old law, the Indian Evidence Act of 1872, and see. And what you see here is pretty amazing. There's a ton of continuity. Under the old Evidence Act, this rule was Section 52. Now, under the BSA, it's Section 46. But the core principle? It's exactly the same. They didn't change the substance of the rule at all. They just gave it a new number. That tells you this is a legal idea that has really stood the test of time. Okay, let's bring this all home. When you put it all together, why does this rule even matter? What's the big picture here? Well, the purpose of Section 46 is really all about fairness. First, it's there to stop judgments from being made based on personal bias or prejudice. It forces the court to stay laser-focused on the objective facts of what happened. But it also does something really smart. It strikes a balance. It protects people from being judged on their past reputation while still making room to examine character when it's genuinely the thing everyone is arguing about. And really, that leaves us with the crucial question at the heart of all this, doesn't it? How does a legal system find that perfect balance between the truth of who a person might be and the cold, hard facts of what they did in one specific moment? Section 46 is the law's attempt to walk that very fine line. It's a delicate dance for sure, but it's absolutely essential for making sure our courts deliver justice based on proof, not prejudice.
आज हम डिस्कस करेंगे अ वेरी क्रूशल सेक्शन फ्रॉम द न्यू भारतीय साक्ष्य अधिनियम 2023. ये है सेक्शन 47.
So, here's our roadmap for today. We'll start with an introduction to Section 47. Uske baad, we'll break it down into its key ingredients. Then we'll look at a practical court example, some landmark judgments, and compare the new BSA with the old Indian Evidence Act. And finally, we'll wrap up with some really important exam tips and a quick revision. All right, let's start with the foundational concept. You know, in any criminal trial, दो चीजें दाव पर लगी होती हैं: an accused person's liberty and their reputation. This is a cornerstone of our justice system, and that's exactly why the law allows for certain types of evidence that can help someone prove their innocence.
और यहीं पर आता है सेक्शन 47 ऑफ द भारतीय साक्ष्य अधिनियम 2023. ये सेक्शन स्पेसिफिकली डील करता है प्रीवियस गुड कैरेक्टर की रेलेवेंस से इन क्रिमिनल प्रोसीडिंग्स. नाउ अगर आप जुडिशरी या एपीओ एग्जाम्स की तैयारी कर रहे हैं तो इस टॉपिक को मार्क कर लीजिए. इट्स एन एब्सोल्यूट फेवरेट फॉर एग्जामिनर्स, बोथ फॉर डायरेक्ट क्वेश्चंस एंड फॉर कॉम्प्लेक्स प्रॉब्लम बेस्ड वंस. चलिए अब देखते हैं इसकी एग्जैक्ट वर्डिंग, जो हम कहते हैं बेयर एक्ट लैंग्वेज. It says, in criminal proceedings, the fact that the person accused is of good character is relevant. Simple language में समझें तो इसका मतलब है कि अगर किसी accused person की reputation अच्छी है, उनका past record बिल्कुल साफ है, तो कोर्ट को इस फैक्ट को कंसिडर करना ही पड़ेगा. इसके पीछे का लॉजिक बहुत सिंपल है. एक अच्छे कैरेक्टर का इंसान क्राइम कमिट करेगा, इसकी पॉसिबिलिटी कम मानी जाती है.
Okay, so basic principle तो clear हो गया. But you know, to really master this for your exams, especially for mains answer writing, we have to deconstruct it. So let's break Section 47 down into its essential ingredients to see exactly what makes it tick. देखिए, यहाँ 4 की ingredients हैं. First, criminal proceedings. ये बहुत important है. ये section सिर्फ criminal trials जैसे theft या fraud में apply होता है, civil cases में नहीं. Second, accused person. जो भी एविडेंस है वो उसी इंसान के कैरेक्टर के बारे में होना चाहिए जिसके ऊपर ट्रायल चल रहा है. थर्ड, गुड कैरेक्टर. और इसका मतलब किसी दोस्त का पर्सनल ओपिनियन नहीं है. इट मीन्स उस पर्सन की जनरल रेपुटेशन, उसकी समाज में क्या इज्जत है, फॉर ऑनेस्टी, इंटेग्रिटी. और फाइनली, रेलेवेंस. इस एविडेंस को रेलेवेंट माना जाता है क्योंकि ये अक्यूज्ड के गिल्ट के बारे में एक रीजनेबल डाउट पैदा कर सकता है.
सो हियर्स हाउ द लॉजिक फ्लोज इन अ कोर्टरूम. पहले एक क्रिमिनल प्रोसीडिंग होनी चाहिए. देन डिफेंस अक्यूज्ड के गुड कैरेक्टर का एविडेंस प्रेजेंट करता है. द कोर्ट एक्सेप्ट्स दिस एज अ रेलेवेंट फैक्ट. और फाइनली, दिस कैन प्लांट अ सीड ऑफ डाउट अबाउट द अक्यूज्ड गिल्ट. अब एक चीज हमेशा याद रखिए, एंड दिस इज अ की पॉइंट. ये इनोसेंस को ऑटोमेटिकली प्रूव नहीं करता, लेकिन डिफेंस के लिए एक बहुत पावरफुल सपोर्टिंग एविडेंस जरूर बन जाता है.
थ्योरी तो ठीक है, बट लेट्स सी हाउ दिस प्लेज आउट इन अ रियल वर्ल्ड सिनारियो. देखिए, प्रैक्टिकल एप्लीकेशन समझना आपके प्रॉब्लम बेस्ड क्वेश्चंस के लिए एब्सोल्युटली वाइटल है, और इससे कॉन्सेप्ट आपके दिमाग में बिल्कुल लॉक हो जाता है. लेट्स इमेजिन अ सिचुएशन. मिस्टर शर्मा एक अकाउंटेंट हैं और उन पर कंपनी के फंड्स एम्बेजल करने का चार्ज है. प्रोसिक्यूशन फाइनेंशियल रिकॉर्ड्स दिखाता है जो उनकी गिल्ट की तरफ पॉइंट करते हैं. नाउ दिस इज वेयर सेक्शन 47 कम्स इन. मिस्टर शर्मा का लॉयर उनकी 20 साल की बेदाग सर्विस और उनकी कम्युनिटी में ईमानदारी की रेपुटेशन का टेस्टिमनी प्रेजेंट करता है. डिफेंस का कोर आर्ग्यूमेंट बस एक सिंपल सा पावरफुल सवाल होगा: इतने सालों से इतने अच्छे कैरेक्टर वाला इंसान अचानक से ऐसा क्राइम क्यों करेगा? Okay, let's move on to the landmark judgments. देखिए, case laws के बिना कोई भी statute just a book of text है. It's the judgments that breathe life into it. So let's understand the key cases that have shaped this section. First up is the classic English case R versus Rodin. इस केस की सबसे इंटरेस्टिंग बात यह है कि इसने कैरेक्टर शब्द को लीगली डिफाइन किया. The court made it crystal clear, कैरेक्टर का मतलब है accused की general reputation in the community, ना कि किसी एक witness का private opinion. मतलब लोग आपके बारे में आम तौर पर क्या सोचते हैं, ना कि कोई एक इंसान. Next, we have a key Supreme Court ruling in Mohan Lal versus Ajit Singh. यहाँ पर कोर्ट ने सीधे good character की evidentiary value को address किया. The court said, yes, this evidence is a powerful tool. It can be used to create doubt about the probability कि accused ने वो offense किया भी है या नहीं. So, the key takeaway, it's all about tipping the scales of probability in your favor.
और our third case, State of Punjab versus Prem Sagar, ये एक बहुत ही fascinating dimension add करता है. The court here held कि good character की relevance conviction के बाद खत्म नहीं हो जाती. In fact, it can and should be considered during sentencing as a factor to mitigate, यानी सजा को कम करने के लिए. ये हमारे legal system का compassionate side दिखाता है. ये पूरा principle एक legal maxim में बहुत खूबसूरती से समझाया गया है. In dubio pro reo. इसका सिंपल सा मतलब है when in doubt, favor the accused. ये क्रिमिनल जस्टिस का एक फंडामेंटल पिलर है कि डाउट का बेनिफिट हमेशा अक्यूज्ड को मिलना चाहिए. और सेक्शन 47 इसका डायरेक्ट एप्लीकेशन है क्योंकि एक अच्छा कैरेक्टर ही वो क्रिटिकल एलिमेंट ऑफ डाउट क्रिएट कर सकता है. नाउ लेट्स टॉक अबाउट द न्यू लीगल फ्रेमवर्क. अब जो नए क्रिमिनल लॉज आ गए हैं, इट्स वाइटल टू मैप द ओल्ड प्रोविजंस टू द न्यू वंस. तो ये कॉन्सेप्ट पहले पुराने एविडेंस एक्ट में कहा था और अब क्या बदला है. So पहले ये प्रोविजन सेक्शन 53 ऑफ द इंडियन एविडेंस एक्ट 1872 में था. अब इसको जगह मिली है सेक्शन 47 ऑफ द न्यू भारतीय साक्ष्य अधिनियम में. एंड लिसन केयरफुली, दिस इज द मोस्ट इंपॉर्टेंट पॉइंट फॉर योर एग्जाम्स. कोई भी सब्सटैंटिव चेंज नहीं हुआ है. द लीगल प्रिंसिपल इज एग्जैक्टली द सेम. सिर्फ सेक्शन नंबर बदला है, सो घबराने की कोई बात नहीं है. जो भी कॉन्सेप्ट्स अपने सेक्शन 53 के लिए पढ़े थे वो सब अभी भी वैलिड हैं.
ऑलराइट, चलिए अब आते हैं सबसे इम्पॉर्टेंट पार्ट पर, आपके एग्जाम्स की तैयारी. ये सेक्शन आपके पेपर्स में कैसे आ सकता है? देखिए, प्रीलिम्स में एक डायरेक्ट क्वेश्चन एक्सपेक्ट कीजिए, जैसे द रेलेवेंस ऑफ गुड कैरेक्टर इन क्रिमिनल केसेस इज कवर्ड अंडर विच सेक्शन ऑफ द बीएसए. सिंपल. मेंस के लिए आपसे एक शॉर्ट नोट पूछा जा सकता है या फिर एक प्रॉब्लम बेस्ड क्वेश्चन, बिल्कुल वैसा ही जैसा हमने मिस्टर शर्मा के सिनेरियो में डिस्कस किया था. तो चलिए एक क्विक रिवीजन कर लेते हैं. 3 चीजें याद रखिए. 1. सेक्शन नंबर है 47 ऑफ द भारतीय साक्ष्य अधिनियम. 2. कोर कॉन्सेप्ट है कि क्रिमिनल केसेस में अक्यूज का गुड कैरेक्टर एक रेलेवेंट फैक्ट है. एंड 3. एग्जाम इंपॉर्टेंस इसकी बहुत हाई है फॉर बोथ प्रीलिम्स एंड मेंस. एंड आई लीव यू विद अ फाइनल थॉट टू थिंक अबाउट. हमने ये तो इस्टेब्लिश कर लिया कि गुड कैरेक्टर अकेले इनोसेंस प्रूव नहीं कर सकता. बट जस्ट इमेजिन अ सिचुएशन जहां सारे दूसरे एविडेंस अक्यूज्ड के खिलाफ है. ऐसे में एक जज को उस इंसान के लाइफ टाइम ऑफ गुड कैरेक्टर को कितना वेट देना चाहिए? इट्स अ वेरी कॉम्प्लेक्स क्वेश्चन एट द हार्ट ऑफ जुडिशियल डिस्क्रेशन. जरूर सोचिए इसके बारे में. दैट्स ऑल फॉर आवर डीप डाइव इनटू सेक्शन 47. For more judiciary, APO, and law exam focused legal content, stay connected with Ganga Education.
Today, we're going to discuss Section 48 of the Bharatiya Sakshya Adhiniyam 2023. Now, this is an incredibly crucial provision, especially when it comes to trials for sexual offenses. For anyone preparing for the Judiciary and APO exams, this section is definitely one you need to know. So, let's dive right in.
Here's how we'll structure our discussion today. We're going to break it down into 5 key parts. First, we'll start with an introduction. Then, we'll dissect the legal language of the provision itself. After that, we'll look at its application through some landmark case laws. We'll also compare it with the old law, and finally, we'll wrap up with some targeted tips for your exams.
All right, let's kick things off with our first section, an introduction to Section 48. Here, we're going to understand why this provision was needed in the first place and what its main objective really is. This is all about getting to the heart of how we ensure justice for victims. So, Section 48 of the Bharatiya Sakshya Adhiniyam 2023, this really represents a major progressive step in our evidence law. It's been specifically designed to protect the dignity and the rights of victims during what is, without a doubt, the incredibly difficult process of a sexual offense trial. So what's the core philosophy here? Well, in the past, a common defense strategy was to attack the victim's character, which basically put the victim on trial. This awful practice leads to something legal experts call secondary victimization. It's where the trauma of the assault is made even worse by the trauma inflicted by the justice system itself. Section 48 acts as a direct shield against this. It forces the court to focus on what matters, the actions of the accused, not the past of the victim.
Now that we understand the why behind this section, let's get into the how. We're going to break down the legal language of the provision into its essential ingredients. And let me tell you, mastering this is a vital skill, especially for your mains exam answer writing.
Okay, this is the key line right from the Bare Act. In simple terms, what it means is this. Whenever the defense raises the question of consent in a sexual offense case, any evidence about the victim's character or their past sexual history is considered irrelevant to prove consent. The law creates an absolute bar. This whole section really hinges on three important phrases. First, consent is an issue. This means the rule only gets triggered when the defense actually makes consent a legal issue. Second, character of the victim. This blocks any evidence about the victim's supposed morals or reputation. And third, previous sexual experience, which means the victim's private history is completely off limits for proving or disproving consent. So to quickly recap the conditions for application, just think of it as a three-part test. 1. The case has to be a prosecution for one of the specified sexual offenses under the BNS. 2. Consent has to be a disputed fact. And 3. The evidence being brought up must relate to the victim's character or sexual past to argue about consent. If all three of these conditions are met, Section 48 kicks in and that evidence is thrown out. Now we're moving on to the most practical part of our discussion, how Section 48 actually works in a real courtroom, and how the Supreme Court has interpreted and really strengthened this principle over the years. Let's imagine a situation. In a rape trial, the defense lawyer cannot ask the victim questions like, "Is it true you were in a relationship before?" or argue to the judge that the victim is a woman of easy virtue and therefore must have consented. Section 48 acts like a legal firewall, blocking these humiliating and totally irrelevant lines of questioning. It ensures the case is decided on facts, not prejudice. Let's start with a landmark judgment that really shaped this area of law even before this specific section existed in its current form. This is the 1996 case of State of Punjab versus Gurmeet Singh. In this case, the Supreme Court took a really powerful, empathetic stand. It observed that victims of sexual assault are already deeply traumatized, and the trial process shouldn't become a second ordeal. The court held firmly that trial judges have a duty to protect victims from humiliating questions about their character. This really set a foundational principle for victim-centric justice. The next crucial case that built on this foundation is State of Uttar Pradesh versus Papu from 2005. This case is cited all the time in mains answers, so pay close attention to the principle it established. Here, the Supreme Court was even more direct, even more absolute. It ruled that a victim's past sexual history is wholly irrelevant when deciding consent for the specific incident in question. The key takeaway is this: consent is a decision for a specific time, a specific place, and a specific person. A victim's past choices have absolutely no bearing on her right to refuse consent at any given moment. The third and final judgment we'll discuss shows the evolution of this principle to a constitutional level. This is Lilla versus State of Haryana, a landmark decision from 2013. In the Lilu case, the Supreme Court went a step further. It held that any practice that delves into a victim's sexual history, including the infamous and now banned two-finger test, isn't just a violation of evidence rules. It's a direct violation of the victim's fundamental right to dignity and privacy under Article 21 of the Constitution. This elevated the protection from a simple procedural rule to a non-negotiable constitutional mandate. So these powerful court judgments heavily influence the legislation. Now, a common question in exams is how the new laws compare to the old ones. So let's quickly compare Section 48 of the BSA with its predecessor. This provision used to be in Section 53A of the Indian Evidence Act 1872. Let me be very clear. The core principle and the substance of the law are exactly the same. The principle has been retained completely. The only change is purely procedural. Where the old section referred to offenses under the Indian Penal Code, the new Section 48 has just been updated to reference the corresponding sexual offenses under the new Bharatiya Sanhita 2023. And now, for our final section, designed specifically for you, the Judiciary and APO aspirants. Let's focus on how to tackle questions from this topic effectively in your exams. For your prelims, you should expect direct questions. You might be asked which section of the BSA deals with the irrelevance of a victim's character, or its corresponding section in the old Evidence Act, which was 53A. For your mains, a short note on this topic is a classic question. Even more importantly, you could get a problem-based question where you have to apply Section 48 to a factual scenario to stop the defense from questioning the victim's character.
So, to wrap up, let's do a quick revision. If you remember nothing else, remember these three things. First, the section number, Section 48 of the BSA 2023. Second, the core concept, a victim's character and past are irrelevant to the issue of consent. And third, its exam importance is very, very high. These 3 points are your key to scoring well on this topic. And that concludes our detailed explainer on Section 48. This provision is a powerful statement about our legal system's commitment to victim dignity. But as we finish, it's worth asking, while the law is strong on paper, what are the practical challenges that still remain in making sure this protection is fully implemented in every single courtroom across the country? That's a question for all of us in the legal fraternity to think about. For more judiciary, APO, and law exam-focused legal content, stay connected with Gunga Education.
Today, we're going to dive deep into a very important topic, Section 49 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section deals with the relevancy of evidence about bad character in criminal proceedings. And let me tell you, for anyone preparing for the judiciary and APO exams, this section is absolutely crucial. So, what's our plan for today? Well, we've got a clear roadmap. We'll start by understanding the core rule itself, then we'll break it down into its key components. After that, we'll see how it works in practice with some real cases, put it into a broader legal context, and finally, we'll wrap up with a guide specifically for your exam preparation. All right, let's kick things off with Section 1. Here, we're going to get to the heart of the matter and really understand the fundamental principle behind Section 49. You can think of this as the very foundation for how character evidence is handled in our criminal justice system. So here it is. Section 49 of the Bharatiya Sakshya Adhiniyam 2023, found in the chapter on the relevancy of facts. As I mentioned, it specifically governs when an accused person's bad character can, or more importantly, cannot be brought up in criminal proceedings. It's a concept that shows up time and again in law exams, so getting a solid grip on it is non-negotiable. Now let's look at the actual text of the law. So if we put that in simple language, what does it really mean? It means the court operates on a very important principle. An accused person should be judged based on the facts of the current case, not on their past reputation or character. This is all about preventing any unfair prejudice from creeping into the trial. Okay, so we've got the main rule down. Now let's do what all good law students do. Let's break it down into its essential ingredients. To really master Section 49, you have to understand each and every component and how they all click together. You'll see there are a few key phrases here. First, this rule is only for criminal proceedings. Second, when we say bad character, we're talking about a person's general reputation, not just a few specific actions. Third, and this is the absolute key, we have the exception. The prosecution can only introduce evidence of bad character after the accused has tried to introduce evidence of their good character. Fourth, this rule doesn't apply if bad character is itself a fact and issue, for example in cases involving habitual offenders. And finally, a previous conviction can be used as solid evidence of bad character. So the process works in a really logical sequence, as you can see here. It all starts with the general rule. Bad character is off the table. It's irrelevant. But then comes the trigger. The defense decides to present evidence of the accused's good character. And once they do that, they've opened the door for the prosecution to come in with a rebuttal. This three-step process is followed by the court to ensure fairness to everyone involved. All right, enough with the theory for a moment. Let's see how this all actually plays out in the real world. We're going to look at a practical courtroom example and then touch upon some landmark judgments that have really shaped how we interpret this section. Okay, so let's imagine a situation. A person is on trial for theft. The prosecution can't just start the case by saying, "Your Honor, this person has a history of being dishonest." No way. But if the defense lawyer calls a witness to the stand who says, "Oh, the accused is an incredibly honest man," well, that changes everything. Now the prosecution gets to cross-examine that witness and ask about all the accused's prior dishonest acts. It's a perfect illustration of the rule in action. Now, when you talk about character evidence in common law, there is one case that is absolutely foundational, the Old English case of R versus Roughton. This is a true landmark judgment that really set the stage and defined the scope of character evidence for courts pretty much everywhere. So, what did this landmark case tell us? The court made a crucial clarification. It said that character evidence is about a person's public reputation, what the community thinks of them.
It's not about one person's private opinion. This is a very fine point, but it's an incredibly crucial one for your exams. So make sure you remember it.
And of course, Indian courts have also built upon this foundation. In Mohanlal versus Ajit Singh, our Supreme Court stressed that this kind of evidence has to be handled with extreme caution. And later, in State of Punjab versus Prem Sagar, the court confirmed that previous convictions aren't just relevant for establishing character, but also for deciding on the amount of punishment.
Okay, let's zoom out for a second. To get the full picture, we need to place Section 49 within the wider legal framework. We'll do that by looking at a classic legal maxim and checking out the section's legislative history.
You know, this entire principle can be understood through a famous legal maxim, e incumbit probatio qui dicit non qui negat. It basically means that the burden of proof lies with the person who is making an assertion, not the one who is denying it. In the context of Section 49, it's the defense that is asserting the good character of the accused, so the burden is on them to prove it first before the prosecution has to do anything to rebut it.
Now, a quick point for those of you who are familiar with the old laws. This provision used to be under Section 54 of the Indian Evidence Act of 1872. The new law has simply renumbered it to Section 49. The court principle, the substance of the law, it remains exactly the same. So that's one less thing to worry about. No substantive changes here.
And now for the part I'm sure you've all been waiting for. Let's get laser focused on exactly what you need to know to ace your judiciary and APO exams. First up, a very important note. Remember that Section 49 is a rule of evidence. It's not a substantive offense. What does that mean? It means it doesn't actually prescribe any punishment. It just governs whether a certain type of evidence is admissible in court or not. So, for your prep, here's the game plan. In your prelims, you can definitely expect direct questions on the section number or the general rule. Also, those two explanations, fact and issue and previous conviction, are a hotspot for MCQs. For the mains, it's highly likely you'll get a short note or even a problem-based question centered on the exception. And here's a pro tip. Always mention the case of R versus Roughton in your answer. It's a surefire way to get those extra marks. So for a quick revision, just lock these three things in your mind. The section number is 49, the core concept is all about rebuttal, and its importance for your exams is very, very high. Got it? And as we wrap up, I want to leave you with a final thought to ponder. Think about this. How does this rule manage to strike that delicate balance between protecting an accused person from unfair prejudice, while at the same time serving the public's interest in making sure that justice is ultimately done? It's a fascinating question at the heart of our legal system. And that's all for this detailed explainer on Section 49. For more legal content focused specifically on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Today, we're going to tackle a really crucial section for your upcoming exams, Section 50 of the new Bharatiya Sakshya Adhiniyam 2023. Now, this section answers a very interesting question. Think about it. In a civil case, can someone's personal character actually change the amount of money they receive in compensation? It's a key topic for both the judiciary and APO exams, so let's really break it down. So the core principle of Section 50 is actually quite straightforward. The Bare Act says, in civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. So what does that really mean in simple terms? Well, it just means that in civil disputes, if a person's character has a direct impact on the compensation they should get, then any evidence about their character is considered relevant and admissible in court. To really get a grip on this section, let's look at its key ingredients. First, and this is really important to remember, this rule applies only in civil cases, things like defamation or other tort claims. Now, when the law talks about character, it actually means two things: reputation, which is what society thinks about you, and disposition, which is your inner nature. But listen, evidence of character isn't always relevant. It only comes into the picture when it directly affects the amount of damages. And maybe the most critical point, and this is a common exam question, is that the evidence has to be about a person's general reputation, not about some specific thing they did in the past. So you might be wondering, how does a court actually apply this section in practice? Let's trace the steps. It all starts with a civil wrong, right? Let's say a case of defamation. The next step is for evidence of the plaintiff's character to be presented. And as we've just established, this can only be evidence of their general reputation. Then, the court has to figure out how this character information relates to the actual harm being claimed.
Finally, based on that assessment, the court adjusts the compensation amount, and in these kinds of cases, it's usually adjusted downwards. Okay, let's make this real with a classic defamation example. Imagine person A sues person B, claiming that B's statements completely ruined his excellent reputation, and so he demands a huge amount in damages. In response, the defendant B brings evidence suggesting that actually A already had a pretty bad reputation in the community. Now, this is where Section 50 becomes the star of the show. The court is allowed to look at this evidence to decide if B's statements really caused as much damage as A is claiming. I mean, after all, you can't really shatter a reputation that's already broken, can you? And look, this principle isn't just a theory. It's grounded in landmark case law. The foundational English case here is Scott versus Sampson. In this very influential judgment, the court held that in defamation cases, evidence of the plaintiff's general bad reputation can be admitted to mitigate, or in other words, to reduce the amount of damages. This case really set a precedent that continues to influence Indian law even today. And it's not just English law. Indian jurisprudence has consistently agreed with this principle. In the notable case of Subramanian Swamy versus the Union of India, our Supreme Court emphasized that reputation is an essential part of a person's dignity under Article 21, and if it's damaged, compensation is justified. Along with that, cases like Dixon versus Smith just repeat the core idea of Section 50. A person's general reputation becomes directly relevant when the court needs to decide the true extent of the harm done. You know, the whole philosophy behind Section 50 is beautifully captured in a fundamental legal maxim, ubi ius, ibi remedium, which simply means where there is a right, there is a remedy. Your right to a good reputation is legally protected. When that right is violated, the law provides a remedy in the form of damages. What Section 50 does is ensure that this remedy is fair and proportionate. It calibrates the compensation to match the actual harm done, not just the technical violation. Now, for all of you preparing for your exams, this next part is super important. This provision isn't brand new. It used to exist in the old Indian Evidence Act of 1872 under Section 55. Now, under the new Bharatiya Sakshya Adhiniyam 2023, it's Section 50. Please, please remember this for your prelims. The actual law, the substance of it, is exactly the same. It's just a renumbering of the section. It's also really important to understand the purpose here. The point of this section isn't to punish the plaintiff for having a bad character, not at all. The court's objective is to give fair compensation that mirrors the actual harm suffered. The logic behind it is simple. If someone's reputation is already a bit tarnished, a new defamatory statement might cause comparatively less damage. And that's exactly why the evidence is strictly limited to general character, so the trial doesn't get bogged down in specific past incidents. All right, let's talk exam strategy, specifically for judiciary and APO aspirants. For your prelims, you can definitely expect direct questions on the new section number, 50, and its old corresponding section, 55. For mains, you should be ready for problem-based questions involving defamation or even short notes on the relevance of character evidence. And the most important thing to take away is the limitation. The evidence is only about general reputation and disposition. Okay, quick revision time. If you remember nothing else from today, please remember these 3 key things. First, the section number, Section 50 of the BSA, which used to be Section 55 of the IEA. Second, the core concept. In civil cases, character evidence is relevant for deciding the quantum of damages. And third, that critical limitation. This evidence is restricted only to general reputation and disposition, not specific acts. And there you have it, a detailed analysis of Section 50. I really hope this explanation was clear and will be helpful for your exam preparation. For more legal content focused on judiciary, APO, and other law exams, please stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share, and subscribe to Ganga Education. Keep learning, keep growing, and stay connected for more law lectures.